Okay, we're live.
Thank you. Good morning. This is Senate Judiciary. We are taking up first S4, an act relating to juvenile and criminal procedures. And I just wanted to open with a couple of remarks. Number one, this is a bill that was developed in consultation with a number of different players. And it is not, there are things here that are controversial that may not be supported by everyone. However, with the help of the Bennington Police Department, led by Chief Paul Doucette, Stu Hurd, representing the town manager's office, as well as a number of others in the Bennington area, and including the administration in consultation with them. S4, and I don't mean to suggest that S4 is supported by everything in S4 is supported by the administration. Don't get me wrong. But it's a lot of issues, and it's designed to deal with the violence that many of us are seeing in our communities recently, particularly firearm violence. And with that, I just turn it over to Eric. And again, I understand that many sections are controversial. Please look at it as a whole package designed to deal with firearm violence, designed to deal with some of the problems that we're seeing in terms of opioid, particularly opiate and cocaine and methamphetamine issues in our communities. That's the reason for the $10 million grant program, to try to let communities find their own ways to help solve this problem. I'm particularly pleased to have Senator Baruth and Senator Campion join me as co-sponsors of this bill. And again, this is the beginning of testimony. We'll hear from all sides. Those of you who are opposed to certain sections of the bill, we will certainly hear from you and why you're opposed. Those of you who are in favor of certain sections of the bill will hear from you and why you're in favor of it. So it's a process. We've been through it on every bill we deal with, but I think you will see a theme this year in Senate Judiciary dealing with violence in the communities. And we are working with the administration as well as others. For example, violence in our emergency rooms will be a topic. Violence in other areas. So it's a theme. We're trying to deal with it, and it's not unique to Vermont, not unique to Bennington. But I ask your indulgence and understanding. It's a process we're going to go through. For those of you who are saying, well, we're not going to get heard, that's not true. I don't think there's ever been a case in this committee, in my years on this committee, where we haven't heard, at least from representatives from every organization that might be impacted by a bill. With that, I turn it over to anybody on the committee who wants to make a comment, and then turn it over to Eric to walk us through the bill.
Thank you. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to do a walkthrough for you this morning of S4 as introduced, an act relating to reducing crimes of violence associated with juveniles and dangerous weapons. I don't know if the committee or Senator Sears, did you want me to share the screen while I do the walkthrough? Would you?
I don't know that. I think everybody's got copies, but if it's easier to share the screen, go right ahead.
No, it's fine with me either way. I just totally up to you.
You have copies. I think we're fine.
Okay, sounds good. All right. So the bill in front of you, Senator Sears, has a number of different provisions. So you've got sort of a unifying theme of an attempt to address. Pause for a moment. Hold the doors open. But it's sort of a unifying theme of addressing juveniles with respect to violent acts, but there's a number of different provisions. You could view them as discrete in some way. They're not all dealing with the same area of law, then all dealing with the same substantive pieces. So I'll walk through each one individually, hopefully give the committee a good background on what's going on with each section. So turn right to section 1, dealing in the beginning with delinquency proceedings. Now, the committee dealt with last year. I know we have some new members, so I'll just give a moment of refreshing our recollection on that. When a minor commits an unlawful act, charges could be brought against the minor either in the family division, treating the minor as a juvenile, or potentially it could be brought in the criminal division, treating the minor as an adult. Whether or not, after the unlawful act has been committed, whether or not that proceeding ends up in the juvenile division, in family division as a juvenile, or as an adult in the criminal division depends on 2 things. How old was the minor when the act was committed? And what was the act? What was the unlawful act that was committed? So those 2 factors will determine whether or not the proceeding ends up in family court or in the adult court. This particular section 1 is dealing with the second of those 2 things, with the nature of the criminal act. There is something that has long been referred to as a list of offenses known as the Big 12. And the definition of the Big 12 is on this piece of paper I'm going to hand out to you. I thought it would be helpful to have. It's just something that the committee will be looking at quite a bit during the session. So I'll just pass it that way for now. You can always refer to it. It's a good thing to have handy because it comes up quite frequently. The gist of the way the legal setup works is that if the minor commits an act which is a Big 12 offense, that's one of those 12 offenses that was on the list that I just handed out. If it's one of those Big 12 offenses, then the proceeding starts in the criminal division. It's a criminal proceeding against the minor if it's a Big 12. If it's a non-Big 12 offense, then it starts in the family division. So that's obviously the nature of the act is a crucial point as to where this proceeding is going to get started. So now there are provisions in law for transfer between the divisions. You can have a motion, the state or the defense of the court on its own motion, have a hearing, that sort of thing. So there are possibilities for transfer, but the default is criminal division for Big 12, family division for non-Big 12. So what's going on in section 1 of this bill? Essentially, in a nutshell, add 3 offenses to the Big 12. That you see listed at the bottom of page 3 and over onto the top of page 4, third one. One thing I'll point out too, just interesting, on line 6, this is just, if you may want to note this, it's helpful to know. You see that the language in legal speak on line 6 says an act specified in subsection 5204A of this title. That means Big 12. So you could write, that's what that is. So you could write right above the Big 12, and you'll see that quite a bit in Title 33. That's the exact phrase. So it's helpful to know, oh yeah, when I see this phrase, it means the Big 12. That's what it's referring to. So one of those 12 events that was on the sheet that I just passed out. So what are the 3 that are added? At the bottom of page 3, over the top of page 4. Carrying a dangerous weapon while committing a felony. We'll see that come up later in the bill. That specific section is being amended as well. If that's an existing crime, carrying a dangerous weapon while you're committing a felony. So that's added to the Big 12. In other words, if the minor committed that offense under current law, it would start in the family division. The proposal is to have it start in the criminal division. Again, subject to ability to transfer, but that's the proposal.
I just ask a clarifying question around carrying a dangerous weapon. Does that actually mean using it in the commission of a felony or simply having it?
Not necessarily. It can be on your person.
So also following up with that, the definition of a dangerous weapon, I mean, is that's including pocket knives? Or is it just firearms? Or
It's not just firearms.
Okay.
And the court has developed a definition of that over time, so it sort of depends on the particular weapon that you talk about. Sometimes they know what they are, sometimes they're not, but it's not defined in statute right there, and it's broader than firearms. Oh, certainly.
But Eric, the prosecutor still has discretion to move it to family court or a youth offender.
No, not the way it's proposed, Senator Sears. The proposal is that it would start, I mean, the discretion that the prosecutor has is could choose to start as a youthful offender proceeding. Maybe that's what you're
Right,
thinking.
okay, that's what I meant, yeah.
That's right, yes. If they chose to file a youthful offender proceeding rather than a criminal proceeding, then they could start it in the family division. That's right.
Well, that's what I meant. To get to family court, they would do they can charge as a youth offender.
That's right. Yes, thank you. So the second offense, you see trafficking a regulated drug. Specifically, that term trafficking is has a specific meaning because it's more than, because if you sort of think of the way the drug offenses are tiered, there's possession first, that's the lowest level, then sale, and then trafficking. Trafficking is more than just sale because it requires minimum thresholds of the amount of the drug, usually very large amounts. So for example, cocaine, 150 grams, heroin, 3.5, fentanyl, 70. So the idea when it was enacted was to create a higher level of penalties for substantial amounts of a given regulated drug. So I think that's what it means by trafficking. So it's not just sort of a general term, it's very specific. So right, what's the third offense that's proposed to be added to the Big 12? Human trafficking or aggravated human trafficking, and that's a term I'm sure everyone is familiar with. It's forcing, coercing, recruiting someone to engage in current sex act. That's there's a number of different related definitions to that, but that's the gist of it.
Is aggravated that there was a weapon involved?
It can be usually child victim makes it aggravating, prior conviction.
Okay.
And there's death or serious bodily injury resulting. So yeah, not specifically weapon, actually. Now that I think of it. So those are the three, and that's the proposal here, as I say, fairly straightforward in the legal sense, adding three things, not the policy sense, it's for folks to talk about, but legally, that's what it does. It proposes to think of it as making the Big 12 a Big 15 in some ways. We move on to the next section, if everybody's ready. Okay, great. So sections 2 and 3 are actually related. They're doing the same thing conceptually. And this has to do with, in fact, there's an existing law on the books. You're looking at page 4, 18 VSA 4252. This is an existing law that prohibits someone from permitting their dwelling or building to be used for selling regulated drugs. All right, that's an existing statute. We've had it since 2007. There's a federal statute on this as well. In fact, another one that I made a copy of, so I thought it'd be interesting. Sometimes it's interesting to compare the state and the federal law. Good one to have it here. There's that one. This is the federal analog that has existed since 86, I think, 1986 is when the federal law was passed. Also prohibits using or knowingly allowing a building that you own to be used for sale of regulated drugs. And this was based on that. When it was passed, the Vermont statute was based on the federal one. And the proposal here is to make 3 different changes to the existing Vermont statute. All right, the 3 changes are, you see the first one right on line 8. Current law is the property owner has to knowingly permit their dwelling or structure to be used for selling regulated drugs. Right? The proposal is that it could be knowingly or recklessly. So there's another mental intent provision that's proposed to be added that would allow a prosecution to be brought for a violation of the section.
Can I just break in, Eric? I just wanted to make clear, this came out of in Bennington, they're trying a civil route. There was I think 10 different families living in an apartment and living in 10 different apartments in a building. And 9 of them were concerned, had complaints of the landlord about drug use and trafficking going on in the building. And they were concerned. The landlord did nothing, absentee landlord. And so it was, that's really where this came from. It might have been an unusual case, but I'm not sure that it wouldn't happen in other areas where the landlord just refused to do anything about the condition. And these families were not in a position to move from where they were renting. Obviously, we all know there's a housing crisis. Sometimes you're stuck where you're at. So that's the genesis of this. Just so there's some framework to why this is in here. Thank you.
Eric, I had a few questions. I was wondering about the the reckless standard and why, what the rationale is between choosing reckless as opposed to choosing negligence or choosing strict liability. Could you expand on that a bit?
Yeah, you'll see the definition is defined at the bottom of the page, and that is, comes right out of a Vermont Supreme Court case called State v. Brooks from 1995. And the idea behind using recklessly was that, it's sort of I don't know if a middle road is the right word, but negligence, as you mentioned, is a lower standard of mental knowledge, right? Reckless, negligence just means lack of reasonable care. You may have known something, you may not have known something. It's sort of a lack of reasonable care under the circumstances. Recklessly, it's a higher threshold. It's not as high as knowingly. Knowingly is high, you have to actually know. Recklessly means conscious disregard of substantial and justifiable risk. Familiar standard for the courts and criminal law. Manslaughter uses the reckless standard for criminal prosecution. So the courts are very familiar with it. Something's been this standard, I say, was quoted from a case in 1995. It's been worked with for a long time. So the idea was have a standard that is workable for defense attorneys and the prosecution. Courts are familiar with it, and not quite as high as knowingly, but not as low as negligence. So I think that was the idea, to kind of be in the middle.
Is it possible to explore the idea of two different pathways for this? Because, my thought is if somebody's an absentee landlord and they're just not paying attention to their property and it turns into a house like this versus somebody who's intentionally exploiting their property to use it for selling drugs or exploiting people who are addicted. I feel like those, there's liability in both, but I feel like the absentee landlord is somewhat less liable if they're just disregarding their care versus somebody who's intentionally exploiting that property. So is that something that?
Yeah, absolutely. You could certainly, like, for example, just off the top of my head, responding to the point you're making, you could have a lower penalty threshold, for example, for the reckless conduct as opposed to knowing conduct might be one approach. But yes, the idea of having a different track is a possibility. You could have a civil violation, for example, potentially have this is a criminal violation. You could set it up maybe as a civil violation if it were a reckless case as opposed to a knowing case.
So let's take a case where other tenants in the building contact the landlord and complain that they believe drugs are being sold.
Right.
Does that put it when we're talking about consciously disregarding, that seems, it's not the highest, it's not knowingly,
Right.
But it's consciously disregarding. So it seems like there has to be some form of evidence that can be shown that they disregarded. So is that the thing you need to show that somebody complained or they visited and saw police there, or am I on the right track?
Absolutely on the right track. That's exactly right. And so it's those sorts of circumstantial evidence that was, if the landlord had heard about those things or heard about the phone calls or the police being called over, those sort of situations is exactly the kind of thing that would, each case is different, but that is the type of evidence that would show that there was a risk that the landlord was aware of and ignored.
But to Nader's point, we wouldn't be saying that a landlord who lives out of state, they're an absentee landlord, and maybe they're bad in other ways, but it would be difficult to show this standard if they hadn't visited, been contacted, or is being an absentee landlord itself reckless disregard?
I would say no to the latter question. But yes, there would have to be some evidence that there was some reason for the landlord to have thought that there was a risk of this and chose not to act. Okay. Whether they were living next door or out of state, whatever it was. So that was the first change to this section. And the second change you see is the struck language in speaking of landlords in subsection B. When this statute was originally passed back in 2007, there was an exception in there for landlords that provided that a landlord would only be in violation if they knew at the time that they signed the lease agreement that the tenant intended to use the building for selling drugs. So if the landlord didn't know at the time of signing the lease that was the tenant's intent, then they couldn't be prosecuted under this. So the proposal is to get rid of that exception, just go with your standard knowing or recklessly lines. And lastly, the last change here you'll see, line 16, is the penalties increase. Currently, it's a 2-year misdemeanor with a $1,000 penalty. The proposal is to make it a 5-year felony with a $100,000 fine. The federal law that I mentioned actually is a 20-year felony, so that's even more serious. But the proposal here is to make it from a misdemeanor to a felony.
Can I ask you a question? It seems like a huge jump to go from a $1,000 fine to a $100,000 fine. And I was wondering why such a huge jump there?
It's just a policy decision for the sponsor, the
Okay.
committee. I think there were probably many criminal defendants lack financial resources. Could be that if it's a property owner, as it has to be in this case, it might be more of a financial resource on behalf of the defendant than it might ordinarily be. So that was one time.
I could answer that question, and it was really because I see many of the folks who are involved in this as being not your average criminal defendant who maybe not have much money. Many of these folks are making big bucks. The amounts of money that's often seized in many of these cases is very large. And so we as sponsors talked it over and went with 100,000. Obviously, that can change between now and the time during markup and so forth if you think the 100's too high. But it was really because in many cases the amount of money that we're talking about is very large.
Mr. Chair.
Yep.
I think is there a reason why it's repeated the definition? So bottom of page 4 and then middle of page 5. Do you have to repeat the definition in each section?
In this case, I mean, you could technically say recklessly has the same meaning as and then refer to the other section. But in this particular case, the reason
Different section.
whole different title of law.
Okay.
Yeah, that's why I just figured it'd be easier for the practitioner or the reader to have it right there. But you're right, you certainly could do it that way.
So Eric, just under the absentee landlord, just out of curiosity, many absentee landlords have what's referred to as an agent or a property manager or whatever else. Do they run any risk during this program, or if they have knowledge of it, or if they don't contact the absentee landlord, who runs the liability there, so to speak?
It's an interesting question, Tendros. So in other words, they wouldn't be covered by the ownership provision. Might it be under the control of the person because it's a property manager? It's an interesting question. I don't know the answer off the top of my head, but
So my understanding with the way the fine and 5 years is that that's a maximum. So in an instance where a defendant didn't have financial means, less than $100,000 could be imposed, correct?
absolutely. So the next section actually fairly quickly in the sense that this is exactly the same as the section we just looked at, except for 2 different offenses. And it's the same 3 offenses. That is one theme you'll see throughout the bill. Remember in the very beginning, the first section we were looking at was adding 3 offenses to the Big 12, essentially. Well, this is dealing with the same 3 offenses. The first one that we just looked at was selling drugs in a dwelling. This one is the other 2, human trafficking or carrying a dangerous weapon. So the prohibition here is to add a parallel piece of law. It does the same thing that the section we just looked at. In other words, prohibiting someone from knowingly or recklessly permitting their dwelling to be used for one of these criminal offenses. In this case, 2 other offenses. They knowingly or recklessly permit your dwelling or structure under your control to be used for human trafficking or aggravated human trafficking or carrying a dangerous weapon while committing a felony. That's a violation. So same idea as the one you're just looking at, except with respect to these 2 other criminal offenses. And you'll see those 3 offenses. It's a common theme throughout the bill. The community grant program in the last section relies on those 3 types of criminal conduct as well. So penalty is the same, 5 years, $100,000. Definition of recklessly is the same as you mentioned, Senator Brewer. But it has to be in a separate section because, as it happens, the drug offense piece that we're looking at first is in the health title of law. That's where that existing statute is. That's where the drug offenses all are. So that has remains in Title 18, whereas this would be put in Criminal Code, Title 13. That's why it makes sense to repeat everything rather than just cross-reference when you have it. Next section has to do with defacing a firearm serial number. We're now getting into a number of provisions to deal with firearms. So before I do a walkthrough of the substantive pieces of these sections, I want to take a moment of interlude and talk to the committee about a very important United States Supreme Court decision that was decided in June called New York State Pistol and Rifle Association v. Bruin. So it's only about 6 months old, very recent United States Supreme Court decision. Very important. The holding of the court in that case was that New York's licensing system for firearms that required someone who wanted a permit or a license to carry a handgun outside the home was unconstitutional. It violated the Second Amendment. That was the gist of the holding in the case. But for purposes of talking to the committee about it, I don't really want to focus on the specifics. The bigger picture is what's important. And the big picture of Bruin was that it completely changed the legal analysis for the way firearms regulations are analyzed under the Second Amendment. Complete change from what had happened before. So prior to Bruin, the way firearms laws or proposed firearms regulations were analyzed was really sort of, and sometimes called a means-end test, sometimes referred to as a balancing test, a cost-benefit test. But the idea is that you have to weigh the court, the court has to weigh the importance of the state's asserted interest in the case. And the state's going to assert a reason as to why this firearms regulation is necessary. And they'll sort of balance that with the cost, the impact on the right to own a firearm as protected by the Second Amendment. And that sort of balancing was engaged in by courts for many, many years as it was analyzing whether or not a particular firearm statute was constitutional. Bruins took a different approach and said that mode of analysis is incorrect. And going forward, that's not going to be the analysis that's going to be used. And laws that were analyzed under that mode of analysis beforehand aren't necessarily going to be constitutional now because it was the wrong analysis. It was wrong at the time, it's wrong now. And the importance of that standard is why I wanted to read it to you, hear it. And it's going to come up a lot, I think, in this committee. So the new standard that the Supreme Court announced in Bruin is as follows. So they were very clear about it. It wasn't ambiguous. Here's the standard. This is what you have to use. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. It's an important point because that's saying that if the conduct that's attempted to be regulated is within the Second Amendment, in other words, it affects somebody's right to use arms to defend themselves, self-defense, then presumptively it's protected by the Second Amendment. It's presumptively unconstitutional.
Eric, can you just say the line one more time?
Absolutely. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. Second sentence, just as important because, okay, well, what if it makes sense? What if the Constitution presumptively protects the conduct? Then what? Next sentence, the government must then justify its regulation by demonstrating that it is consistent with the nation's historical traditions. So, presumptively protected. If it is, then burden falls, see that shift burden to the state. The burden then falls on the state to justify the regulation by historical analysis. We're going to have to look at the nation's history of firearms and determine whether or not that sort of regulation is, as I put it, this test requires courts to assess whether firearms regulations are consistent with the Second Amendment's text and historical understanding. As you can see, it's a lot of history involved in what's going to have to be analyzed there. And it's completely different than what the test had been prior to Bruin. That balancing means end test that I just talked about, that is not this test at all. This doesn't do any balancing. It just says, is it covered by the Second Amendment? And if it is, historically, is it consistent under the Second Amendment to regulate that kind of conduct? That's the new analysis. And there are literally, I don't think it would be an exaggeration to say that there were hundreds of cases that were decided under the Second Amendment, under this pre-Bruin standard, under what the analysis was believed to be at the time. And all those cases are, in some ways out the window. They're going to have to be reevaluated by the courts under this new standard, and that has started already. There are dozens and dozens of cases going on right now throughout the country in which even statutes that were held to be constitutional under that pre-Bruin standard are being relitigated. They're being reanalyzed under the application of this new standard. And it's happening. It seems like almost every day. Literally, Monday there was a case in the district court in New Jersey that found that New Jersey's firearm statute that had to do with sensitive places. That's one approach to firearms regulation to say, there's sensitive places in which firearms won't be allowed, whether it's hospitals, as this legislature passed last year, whatever they may be. New Jersey court, federal court down there found their sensitive place regulation unconstitutional under the new Bruin standards. Last week, a New York State court found that their ERPO statute, the Extreme Risk Protection Order, unconstitutional under the Bruin standard. On the other hand, again, just interesting that the defacing firearms serial number was the next section, the first one we were going to get to on page 5. Within the last couple of months, there have been 3 different federal court decisions analyzing that federal, not the state one, obviously we don't have it yet, but the federal defacing the firearms serial statute. Remember I said it was based on a federal statute. 3 different federal courts have analyzed that under Bruin. 2 of them have said it's actually okay, that it passed the new Bruin standard. 1 of them said that it didn't. But you got 3 different courts using the same standard announced in Bruin, reached different results. I think that illustrates how unpredictable this is.
So in terms of needing to go to the historical tradition, obviously historians, like everybody else, have different opinions. I know you could probably spend all day talking about what they mean and how you would apply it, but what would you say is the evolving standard for whether your history is correct? If you're a lawyer arguing in favor of this defacing statute and you tell a historical story where the founders on up would have been okay with this, is there a sense of an authoritative source or procedure that people are using to create their historical argument?
Well, authoritative source, I don't know the answer to that, but procedure, interesting to bring that point up. What I've noticed is that many of these courts are hiring experts. They're appointing historians and other experts to provide expert testimony as to what the historical record is. In fact, there's a case going on in Bennington right now where this exact fact pattern is emerging. The Max Mish case, which I'm sure the legislature is familiar with. And Mr. Mitch, a couple of years ago, already raised and litigated the claim that he's being prosecuted under the Vermont statute that prohibits high capacity magazines, right? A couple of years ago, he raised and litigated the issue that high capacity magazine statute violated the Second Amendment. He also made the argument that it violated the Vermont Constitution as well, but that's a separate case. I'm not talking about that right now. He made the Second Amendment argument. He lost. The court ruled against him. Just within the last week, he's re-raising the same argument, violates the Second Amendment, but using the new Bruin standard. As I mentioned, this is happening all over the country. It's not unusual and probably has to happen because the standard is new. And the court said this is the way these things should have been and now have to be analyzed. So that's what's happening. And the court, I noticed this week, allowed both the state, who's defending the statute, and the defendant's lawyer to appoint expert historians. The state has wanted a professor of history. I think they got a professor of history, a professor of political science, professor of law and policy, all going to be appointed and relied on for purposes of developing exactly the kind of point that you're talking about, Senator Booth, which is analyze the history and make their arguments. And then I think it's I'm going to be up to, and then a couple of the cases actually that I noticed, federal cases, the court also appointed their own expert. So there's a funny line I thought was funny in one of them. I'm trying to track down with the court in the opinion, talking about appointing the expert, said, federal judge, this judge is not referring to himself. This judge is not a historian, so I need help. So it occurred to me while I was thinking about my own presentation, which I was doing a lot this year, that I could replace those words, this court with legislative attorneys or not historians. We don't have the resources or the expertise to answer that question about what was the 19th and 18th century history that's going to inform this decision. But there are people who do, and I think that those are the ones who courts and litigators, people challenging the statute and people defending it, are going to have to rely on.
Go ahead.
No, I just wanted to think about, it's an interesting discussion, but I honestly thought sections 4 and 5 were no brainer. Put them into the bill. I had no idea.
Yeah, I think Senator Sears, that's a good point in that because this standard is entirely new, regulations that might have been assumed to be constitutional before the Supreme Court issued its decision in Bruin may not be. It's impossible to.
I mean, I just kind of, when we first were talking about this, I know that some of the other firearm provisions will be controversial, but I thought, who would argue, again, who would argue for straw purchases, for example? Drugs, trading guns for drugs. Who's in favor of that? But I guess we will see.
Well, one of sort of going back to the unpredictability point, and then I'll close this as sort of interlude discussion on the Second Amendment and the Bruin decision. Is that one of my favorite quotes that one of my law professors said I always remember, which I took with me, which is that the Supreme Court does not have the final word because they're infallible, but they are infallible because they have the final word. Right. So they have the last word on this. And I think any realistic appraisal of the legal situation has to conclude that this Supreme Court is more likely to look favorably on arguments that firearms regulations are unconstitutional under the Second Amendment than the court would have beforehand. Having said that, though, I don't have a crystal ball, and I don't know how these cases are going to turn out. I don't think anybody does. So that doesn't mean that you can, as a policy matter, decide what legislation it is that you want to pass. But I think as your attorney and as your legal counsel, it's important that I at least let you know that that legislating in this area is probably, it's always legislating is always unknown in a certain sense, but this is probably more unknown and more uncertain than it has been in a long time. You should at least go into it, whatever you're going to do with this bill or any other firearms legislation, just with your eyes wide open on it and knowing that what could happen in the future is a bit
Again, I would urge us to carefully consider all of the provisions, but I think 4 and 5, I would hope are fairly safe. I think there could be a lot of discussion about some of the other provisions that affect firearms, but as you said, there were 2 that upheld the defacing and 1 that didn't. So I don't know how that all works out.
So turning to the substance, as you were mentioning, Senator Sears, Section 4 has to do with defacing the firearms serial number. This is also based on a federal law, federal statute already has been on for quite some time that basically provides that all firearms have to have serial numbers engraved on them, and it's a federal crime to possess one that doesn't have it. It's also a federal crime to deface a serial number, and that's what this provision enacts in state law in Vermont based on the federal law, makes it a state crime, so that this is something that happens not unusually in judiciary committees. The fact that a federal prosecution, but right now, because it's only federal law, it would have to be brought by a United States attorney in federal court. So it would be prosecuted for this. You make it a state law, it's a state violation as well. It could be brought by a Vermont state attorney in state court. It provides them that opportunity in the event that, for whatever reason, the U.S. attorney wasn't bringing the case. You have that option. Yeah, please, sorry.
I know this is a very small percentage, but antique firearms that may not have their serial numbers, or that they may have been eroded over time.
Correct.
Or they just didn't come with serial numbers 100 years ago.
Yeah.
With those, how would that work with this provision?
They're excluded.
They're
So
excluded.
the definition on the next page defines firearms, and I did repeat it here, but it uses an existing firearms definition that's in the prohibited person statute, and that definition excludes antique firearms. So, yeah, musket loaders, black powder, firearms manufactured before a certain year, that sort of thing. So it's a good point. Thank you. So it's a 5-year felony. You see the facing firearm is a 5-year felony. That's the same as the federal penalty. One other point to make on this is subsection D over on page 6. This is one other piece I want to pass out. So you see what's proposed to be done there. In addition to creating this new crime, it specifies that if you violate this offense, it goes to the roof. It's considered a violent act for purposes of determining bail. So what is that? Well, what that means is that generally speaking, there are certain requirements that have to be met in order for someone to be held without bail. Right? There's several legal components that have to be satisfied. One of them is it has to be a crime of violence, it has to be a violent offense, and that's why it's specified that this conduct does constitute a violent act for the purposes of determining bail. So if you look at that statute I just passed around, it says a person that is charged with an offense that is a felony, an element of which involves an act of violence against another person. Right? Ordinarily, that's something that the court's going to have to figure out. That's a court determination. It's not unusual for the prosecution and the defense to argue about that. Well, this isn't a crime of violence. Yes, it is. You avoided that argument if you passed this statute, because this is defining it that way already. So you would have met that fact. Bail with the evidence that feels great, and the court finds, based on clear and convincing evidence, that the person's released. I think poses a substantial threat of physical violence to any person that no combination of conditions will be. So there's still a court decision to be made. It still has to determine if those other factors are met as well. But as far as whether it's a crime of violence or not, that would be established by this language.
And this language of shall means that it is automatically considered a violent act, not able to be considered a violent act.
Yeah, that's right. It wouldn't be something that the parties could argue about. All right, so next offense, straw purchasing. Senator Sears said this also is a federal law. Well, this one quite recent. This was actually passed just last year in June by Congress, and what I'm sure folks have heard about, the Bipartisan Safer Communities Act that President Biden signed in June. So this piece was in that. So this language is based on what Congress just passed, the straw purchasing. Basically, what is straw purchasing? It means when you're buying a firearm on behalf of another person who you know is illegally prohibited from possessing a firearm or is planning to use it for some illegal purpose. So you're not buying it for yourself, you're buying it for somebody else, and they're going to use it for something illegal, or they're not legally supposed to have it. That's essentially what straw purchasing means. And so this prohibits that type of purchase. You'll see that it's defined to be, if you know, it's lines 13 and 14, the purchaser knows or reasonably should know that the other person is prohibited from possessing a firearm by state or federal law. They intend to use it while they're committing a felony, or if they want to transfer it to another person who is either prohibited or is going to use it for a felony.
So quick question
Yes.
about on line 13 regarding demand. So my curiosity is, if somebody's committing a crime, there has to be the voluntary act and the mens rea or the intention. And how is that determined if somebody is demanded or if they're under duress to purchase a firearm for somebody who's disqualified?
Yeah, it's an interesting question. That language is modeled on the federal language, which is pretty new. So I think it would be a very fact-specific inquiry, but you're right, that sort of raises that, what about that sort of fact pattern where the person, say, is being threatened or, at the demand of somebody else, if they're threatening them with physical violence, if they don't go buy that firearm for that. It does seem like that potentially could fall under the wording of demand. And again, this is such a new area of the law. I don't know the answer for sure, but I agree with the point that arguably demand could cover that. So maybe if you didn't want that sort of fact pattern to be covered, you might want to think about whether you want to keep that word.
Yeah, I definitely want to put a pin in that for the future because I just think there could be issues with the voluntary act, right, the intention of committing this crime. So yeah, so just want to put that out there.
Yes.
Senator Close.
Thank you. I'm wondering if there is some sort of legal back precedent or a way of just defining what someone should have reasonably known.
Yes, is the answer. That is a phrase that is common in the law, in the criminal law as well. There's a number of statutes that use that. It is legitimately a point of discussion. It's always, because I think you're right to identify the policy discussion, which is if they don't actually know, is it equitable to charge someone with criminal conduct? But the answer is yes, it does happen sometimes. There are the criminal statutes that do it. It's a matter of evidence. It's a matter of almost like when we were discussing the landlord earlier. What facts are there out there that would show that, given A, B, C, and D, given that, the person drove them up to the firearm store and you knew the person was a friend of yours and you knew they had been convicted of several felonies. And the person didn't say to you, yeah, go buy that gun for me and I'm going to take it. But should they have known in that situation? Every fact pattern is different, but I think it's a good point that it's different than actual knowledge, and it's always something to bear in mind.
It's hard to imagine a situation where someone asks someone else to buy them a firearm, which requires a background check, where that person wouldn't say, why can't you buy it yourself? Why are you making me do the background check? The only thing I could see there would, because the immediate assumption would be that they're having to do it because they can't get it. Like saying to somebody, will you go buy beer for me when you're 16? Everybody knows what's going on. But I could imagine a situation where they would come up with a story that maybe could exonerate the person who buys the gun. But I think that would be the rarer instance where somebody would actually be able to show that they didn't know they were evading the background checks.
And sometimes the language is sometimes used to address a situation to avoid someone being able to claim willful ignorance, that I intentionally made sure so that I could technically legally say, oh, I didn't know because they didn't want to know. Sometimes that's a rationale for having that approach. So that's the straw purchasing piece. This last piece you see it also has a 5-year, $100,000 penalty at the bottom. Just FYI, the federal felony is a 15-year or 25-year felony, depending on the circumstances. But this one's fine.
So what's the fine for the federal one? I'm just curious. Compared to this.
I'll look that up.
No worries. That was just a small curiosity.
Yeah. Let's see. We're moving on to page 7. You'll see again parallel language there, subsection D that we already talked about. This offense also, this proposal is to have that be considered a violent act for purposes of bail. See, that's the same as what we just thought. So moving on now to the next section. This has to do with prohibited persons. So Vermont does have a law that was passed in 2017 that prohibits firearms possession by persons convicted of certain crimes, right? Passed in 2017. All 50 states have a similar law. the Congress has passed a similar law a long time ago, so federally there's a similar law as well. The federal law not only prohibits people who have been convicted of certain crimes, but people who have fallen into other categories. And what this proposal is to do, you'll see, is to add a few categories that also exist in federal law to the state prohibited person statute. That's the proposal here. So the federal law, you'll see 1, 2, 3, 4 on line 7. These 4 different things are already covered by federal law. They're all, in other words, these folks are already prohibited from possessing firearms by federal law. This is proposing to make it a state offense as well. What are these categories? Fugitive from justice, which is defined in the statute, changes the federal definition for this person who has fled to avoid prosecution for a crime or to avoid giving testimony in a criminal proceeding. Person who is subject to a final relief from abuse order or a final stalking order. That's 2 and 3. Those are also covered by federal law. They weren't covered by state law. So if you've got a final RFA against you or a final stalking order, you're not supposed to possess a firearm. However, the way it's phrased, if the order expires, you're no longer the subject of the order. So once the order expires, then you could possess firearms again. So it's not a lifetime prohibition in that sense. It's only a person who's the subject of the order. And lastly, someone who's been charged with, and there's these 3 offenses that we've seen in a number of instances throughout the bill, the same 3, that have been charged with. Again, this isn't conviction, this is charged, and that's a different thing. Law doesn't cover that at the moment. Federal law does. Federal law covers it, not only if you've been convicted or if you've been under indictment for one of the listed offenses. It's covered under federal law.
Eric?
Yes.
When it says charged with, does it mean currently facing charges or in the past charged with?
Very good point. I thought of that. That may be a correction that you would want to make, because I only thought of that recently myself. That literally the way it's read, I don't think it's the intent, but I think literally the way it's read, it could have been charged anytime,
Right.
as opposed to still subject to the charges. Pending charges might be a better way to put it.
Yeah.
So those are the same 3 offenses, again, the human trafficking, weapon while committing a felony, and trafficking of drugs.
I have a question, and you may not have the answer right now, but it's around our human trafficking statutes and whether or not those take into consideration that a lot of times the victims of trafficking become traffickers themselves in order to not be in as terrible or as abusive of a situation. So I just don't know our trafficking statutes well enough to know if that's considered in them.
And the answer is yes, it is considered, but the specifics of that, I don't have that off the top of my head, but I do remember quite clearly that discussion. And then there are allowances made for a victim in human trafficking cases. I wouldn't want to say that I remember exactly what they were, because I don't, but I can look that up for you. Yeah. Okay, so moving to the next
Eric,
one.
can I do just an administrative thing for right now? It looks like we're taking longer than I expected. And I wanted to get through at least and give the administration an opportunity to testify. So I think what we're going to do is cancel S6 today and pick up on that tomorrow, next week. If you are able to continue your walkthrough, and then after a short break, find some time for the Jay Johnson and the members of the Jay Pershing Johnson and members of the administration to comment if they wish, and then end at 11:15. If that works for everybody.
That's fine with me, Senator Sears. I could keep going through as long as you need.
Okay. Well, why don't we try to get through the walk through the bill, and I don't want, and then we'll take a short break.
Yeah. Right. Okay, so moving on to the next section, this is something we've referred to a couple of times already. This is the offense that we've mentioned, which is carrying a dangerous weapon while committing a felony. As you mentioned, Senator Byhowski, it's the language there on line 11, it says existing law is carries. So not necessarily that you used it to commit the felony, but you had it under person. So that's existing statute. What proposal is made to change this? Again, something you've been looking at in several other places. It's subsection B. Just adding the point that if you violate this offense, it's going to be considered a violent act for purposes of bail. So if someone commits this offense, they, assuming the other factors are met, they can be held without bail. Under current law, one could argue in court whether or not that constitutes a violent offense, but you might win, you might lose. So this makes that standard the law, shall, as you mentioned, shall be considered a violent offense. So if the other criteria are met, the person who allegedly commits it can be held without bail. That's the proposed change there. Moving on to section 8. Now, this is a firearms case that involves essentially, in a nutshell, prohibiting possession of semi-automatic assault weapons by persons aged under 21. So it's an under 21 prohibition on possession of semi-automatic assault weapons. That prohibition is over on the top of page 9, subsection A. That's where the language is. It is a 1-year misdemeanor. That's subsection B. That's consistent with many of the firearm statutes that we currently have.
And Eric, just to stop, it wouldn't change anything if we eliminated the word assault. The definition would still hold as written in the bill.
Yes, it's in a sense, it's a legal construct, to say,
Yeah.
here's how we're defining the term. You can, if you want to change the term, absolutely.
Because I think I would suggest that as a change in phrasing, because I know that there are folks who thinks that's not
Accurate, perhaps.
yeah, not a descriptive term or that it's inflammatory. So it doesn't change the operation of the language. I'll suggest that moving forward.
Okay. Yeah, it certainly would. Because the key is just how you defined it, not what you named it as.
Right. So we would use semi-automatic weapon rather than semi-automatic assault weapon.
Sure. And the definition, the substantive definition, I should mention, that you see starts on line 13 and goes on for quite some time. It's obviously has to do with the operation of the firearm, and it's defining it in terms of the features that the firearm has. If it's a semi-automatic rifle that can accept a detachable magazine, it has to be one of the following features. So it's got to be accept a detachable magazine, have one of those features. It's a feature test, is what it's called. That test was virtually identical to the one that New York has and that Connecticut has. And both of them were upheld by the Second Circuit and a major Second Amendment case, but that was pre-Bruin. So remember what goes back to our firearms discussion earlier. Under Second Amendment analysis as it existed prior to Bruin, I would have said, for now, you're all set with this because the court specifically upheld it. Now, I'm not saying it's not all set, it might be fine, but it's unclear now. So and in fact, now I think that the lawsuit has already been filed in New York, I think, to challenge their semi-automatic assault weapon statute under the new rule test, but still, I think it just got filed previously. So we'll have to wait and see how that turns out. Almost done. So anyway, yeah, so that's the, you'll see there's exceptions for the military and law enforcement, the feature test that I described based on the New York statute. And actually that same, there was a assault weapons ban, again, for lack of use that term at the time, federally, from 1994 to 2000, it was in effect for 10 years, but it sunsetted in 2004, and that used that definition as well. So in common use. States that have chosen to go that route. So there's some exclusions at the end of the section as well. I wouldn't have anything really more to add to that section unless someone else wants to ask specific questions about it.
No.
All right, so now section 9. This is a section having to do with juvenile proceedings again. So we're coming back to the juvenile proceedings issue that we were talking about in the beginning. This is the purpose of this section is to make a change in Vermont law to coordinate it with another piece of the Bipartisan Safer Communities Act that just passed in June. So Congress just passed this act in June. And we mentioned earlier that it had a piece in there on straw purchases. Remember that? It had a number of pieces in there. And another section had to do with NICS, the National Instant Criminal Background Checks. And everybody remembers what that is. That's when someone wants to purchase or a firearm is transferred, you have to have a background check. And that check is conducted at a federally licensed firearm dealer, and they contact NICS And Nix runs a background check to see if your name comes up for having committed one of the criminal offenses, or maybe been subject to a mental health proceeding, or any one of the other reasons that would make you a prohibited person. The issue is that under current law, there is no specific allowance for Nix to check a juvenile record. And juvenile records, as you know, are confidential. So unless there's been some place in state law that has made an exception for the confidentiality of juvenile records, they can't be looked at by anybody other than statutory. And there are statutory exceptions, law enforcement, there's a few others as well, but crime victims in certain circumstances. But generally speaking, confidential. So in the Bipartisan Safer Communities Act, Congress said to Nix, you have to contact each state's, if it's somebody under 21 who's being transferred a firearm, then you also have to contact each state's repository of juvenile records to find out if there might be a juvenile offense that would disqualify that young person from buying a firearm. Obvious problem. In states then have to say, well, all right, but what if the state law doesn't allow that? So that's what this proposes to do, to amend state law to permit Nix to access these juvenile records when someone under 21 is going to be transferred a firearm.
And
Sorry, go ahead.
so I'm just hoping my understanding is right. Not that they would be able to access our sealed records, but that we would be required to transfer information from the sealed records to the Nix database. Yeah. Okay.
And for when the purchaser is under 21.
Yeah.
Yes. Or sorry, transferee. It doesn't apply to this for purchase. It could be when you're giving someone a firearm, you're supposed to do a background check as well. So yes, that's the idea. Just as a moment or two of background, I worked on that language with Judge Zone and the court during the off season, so we knew this was coming up, and so the court is, as far as I know, on board with that approach as well. The language that you see, which is over on page 12, the new language. So you see lines 12 to 17. Again, general rule, juvenile records confidential. Here's a couple of exceptions. One of them is in existing law. Such records and files shall be available to, right? Available to existing states attorneys, other law enforcement officers. Subdivision 2 adds the National Instant Criminal Background Check System in connection with a background check conducted on a person age 21. So as you mentioned, they're conducting the check. They get in touch with our local, could be BCIC. I'm not sure how the court's mechanically going to do this. That would probably be a good question for when you have a witness from the court. But the idea is to at least provide them with the legal authority. And that's the essence of that piece. And then lastly is the grant program. So this is creates a community safety grant program. The proposal is starts over on page 13. Substantively, it's administered by the Department of Health in conjunction with Public Safety, the Director of Violence Prevention, and the Executive Director of Racial Equity. And the sort of operative language here is lines 5 to 8, establishes a process for a community where there has been an increase in violence associated with illegal drug use, gang activity, or human trafficking. Remember, it goes back to those 3 offenses that you've seen in a lot of different ways throughout this bill. Increase in violence associated with those offenses, drug use, gang activity, human trafficking, to apply for and obtain grants to assist the community with community outreach and intervention, violence prevention, and reducing demand for illegal drugs. So that's the idea behind this grant program. It's administered and at the discretion of the Commissioner of Health. The Commissioner decides who's going to get these grants. Municipalities can apply for them to the Commissioner of Health. That's subdivision B. And the grants are awarded, again, for the purpose of community outreach and intervention, violence prevention, reducing demand for illegal drugs. Then there's some language about the process, what has to be in the application, has to describe how the community has been impacted by this increase in violence. That has to be specified in the application. They have to have a detailed plan for how they're going to address it with their proposal for a program to be supported with grant money, document personnel needs, and then if they're successful, then awards are made directly to the municipality. And the commissioner is allowed to adopt rules for timelines, application criteria, et cetera. And then lastly, the last section is an appropriation. You see there's a $10 million appropriation from the general fund to provide money that communities can apply for these grants. So a $10 million pot of money that's an appropriation to allow the grant fund to award these grants. But there is a provision also basically saying that, if there are federal grants or legal settlements available, then the grant program is able to access those federal grants or legal settlement monies, then the grant appropriation would be reduced by a corresponding amount. So in other words, they can get some of that 10 million from a federal grant or from a legal settlement, then the 10 million can be offset by the amount that they got from one of those other sources.
Question, I was wondering if you could go, if you have the information, if you could go more in depth as to what the money can be used for. I mean, will it go to community justice centers? Will it go to police departments? Will it go to harm reduction? Or is that to the discretion of the community?
Yeah, I think it's gotta be in the plan, but I think you're right. Any one of those folks could be part of the plan, the proposed plan, I should say, that the municipality would submit. Yes.
I can say the intent is more like it's based on something that was done in Massachusetts this summer. And the money was, I don't know where the money came from, but it went to certain areas of the state that had this increased violence. And it was through the state's attorney's offices down there, or district attorney down in Mass. But the goal is not to have money go to, for SWAT teams or something like that, but rather for, maybe in some communities, harm reduction programs. I'm thinking of Project Vision in Rutland that they did a few years back that seemed to help reduce some of their crime. So those kinds of unique programs that would fit a community.
And it seems as though it's sole discretion of the Commissioner of Health. So I would imagine if we didn't put in more direction, they would probably develop a set of guidelines for how to be successful with those grants. But I think it's a fair question. Right now, it doesn't necessarily delimit the universe of things that people might think would affect these. And there's no standard as such for the Commissioner of Health to use. It's kind of, is it intended to do these things rather than how will the money be used? So that's worth thinking about.
I'm open to any restrictions. Personally, I trust that we would provide a little more guidance. Maybe the administration has suggestions too.
I think I was going to add to that was that the rulemaking also permits the commissioner to adopt rules on additional application criteria. That's another option there, but again, you may want to be more specific in statute as to what that should be. So that pretty much finishes my walkthrough. The act takes effect on passage of the effective date. That covers, I think everything I was told to cover this morning.
Thank you for the in-depth walkthrough. Are there any other questions from anyone?
Why don't we take a 10-minute break and get back and hear from the administration?